Well, welcome everybody who's joined us to this webinar. The background to this is that we had a road transport briefing on the 5th of November. That was the day when DVSA published its most recent amended guide to maintaining roadworthiness. And I thought it would be a good idea, because we weren't able to deal with it then, to sort of run through some of the information. We've advertised this session rather grandly as a webinar, as if we're the only ones, I'm the only one who's going to be doing the talking, but we would welcome any contributions. And if we just move on a slide, we can just explain how this will work. In essence, if you want to raise your hand at any time during the presentation, we can deal with any questions arising. It might be an idea just to hang on for a short while until we get to the end of a natural section break. So the biggest chunk of this will deal with brake testing, and you'll see that also on the presentation is Dave Cooper from Prestige Transport Compliance and Training, who, like the 7th Cavalry, is going to help me with the technical aspects of some of this. I am the first one to admit that I struggle a bit with some of the real technical detail, and Prestige offer a rolling road brake testing accredited training program in conjunction with another provider, so he is actively dealing with some of the practical stuff that we deal with. So a little bit later in the presentation, I'll ask him if he can pick up and do a section of it. So if we could move on, please. To the next slide. Just a reminder that at Ashton's we do have an all-embracing business law unit offering. So not only do we assist businesses with road transport and regulatory and criminal defence, we're able to look after your interests with commercial property, company commercial and debt collection, all sorts of offerings. So do bear us in mind for your wider business needs. Next slide, please. So I thought what we would do in this session is have a little look at the guide to maintaining roadworthiness and the major changes, which really centres around the issue of brake testing, and particularly the issue of starting to do risk assessments. I thought we'd look at what's the legal status of the guide and where we think we are with the Traffic Commissioner and DVSA in terms of their expectations. Now, interestingly, about a week after this was published, I was doing a public inquiry in Cambridge, and the Traffic Commissioner said to me, "Mr. Ridyard, would your client like to offer an undertaking on their licence for laden brake roller testing at every single inspection going forward?" And I sort of carefully said, well, I'm just thinking about the new guide to maintaining roadworthiness and whether or not the undertaking should be worded to the effect that brake testing shall comply with that guide. And interestingly, and it's entirely consistent with the way that traffic commissioners, I think, deal with things at hearings, that Deputy Traffic Commissioner said, well, no, actually, that isn't sufficient. I want laden roller brake testing at every single inspection, and that is what it's going to be going forward. So I think often it's a tougher approach than the minimum requirement in the guide. And I've flagged up there a query whether or not we think that this guide is a greater clarity or it's a lost opportunity. I think it's a bit fudgy, if I can say that, in its guidance. It could have been clearer, and you may have your own views about that. So next slide, please. So in short, the real changes in the guide are very much centered around brakes, in particular the regime that there will be from 2025 onwards, and I'll explain that in a moment, which methods are acceptable, and this issue of risk assessment. It goes on to provide a reminder about your obligations so far as maintenance contractors are concerned, and safety recalls, and there are other minor cosmetic changes. And on the right there, you'll see a reminder of the Bath tipper haulage case, which of course was all about brakes and an abject failure by the maintenance provider to maintain properly on behalf of the operator a few years ago, which led to fatalities, where I think there's only one part of one axle that was actually compliant as far as brakes are concerned. So next slide, please. So if I can just perhaps touch on for a moment the background here. In my experience, the issue of particularly brake testing has been really the top of the hit parade in terms of DVSA inspections and visits and DBA assessments, the desk-based ones, and also hearings with the Traffic Commissioner. It crops up at almost every single one in some way. And one of the problems is the issue of maintenance contractors. And I was informed by a maintenance contractor last week that apparently there is no need to be doing roller brake testing at all until April 2025. Until then, you don't have to do anything, which of course is absolute nonsense, but is not untypical of the way that maintenance contractors deal with matters. Some are very good, but some are very misleading. And that operator has produced, that maintenance provider produced a set of inspection sheets in respect of which there were no performance assessments at all. And it simply said road test okay on every single sheet, which is just miles away from expectations. The other issue is that we see at hearings is the Traffic Commissioner probing operators and transport managers about their understanding of how to read brake data, and Dave will touch on this and the particular problems there in a moment. So next slide, please. So let's just go back and look at what the Guide to Maintaining Roadworthiness actually is now, and what is expected of all operators. Now, I've quoted this from the Senior Traffic Commissioner Statutory Guidance and Directions document number 1. If you're not already familiar with that, as an operator, you have to read it's mandatory. You have to read the provisions, and the particular ones you need to be looking at are number 1 on repute, 2 financial standing, 3 important 1 on transport managers, 6 on driver conduct. I would advise. And in this, in the current Senior Traffic Commissioner guidance, they expressly say make reference to the Guide to Maintaining Roadworthiness, and the guide says operators are expected to follow best practice guidance, refers to a case called Lineage, which will be the next slide we'll talk about, and then specifically says you should be looking at the guidance documents on how to read brake test reports. So it's quite clear that is what the expectation is. So next slide, please. Now, there has been a recent case called Lineage. I think it's pronounced Lineage rather than Lineage. And in this case, in 2023, they look specifically at the status of the guide, because there was a legal argument that the Traffic Commissioner was elevating it to a legal document. Well, it isn't a legal document, but it has to be followed to comply with your legal obligations on your license. And in the case, what had happened was that there'd been an S-marked, so serious shortcomings, S-marked prohibition for a brake-related prohibition, and there'd been some annual test failures for brake-related matters. That's what had brought the operator to the hearing. And it went to an appeal, which we don't need to worry about. The appeal failed, in fact. But what's interesting is what the Traffic Commissioner, it was the North West Traffic Commissioner, said. The upper tribunal accepted that this was just a guide, but they quoted what the Traffic Commissioner was saying. And the Traffic Commissioner said, I find that the operator did not have a process to ensure that vehicles were roller brake tested with the frequency recommended by the Guide to Maintaining Roadworthiness. This led to the S-mark prohibition that was issued in April 2022. He goes on to say, the assessment of brake performance is a basic competency for ensuring the safety and roadworthiness of large goods vehicles, and said it's behind the revisions in the guide. So again, the guide is being quoted again and again and again. And then finally, transport managers, please note, the failure to ensure that an operator's vehicles were brake tested at the recommended frequency would usually result in a transport manager's repute being marked as at least tarnished, if not lost. So if we just digest that, that's a fairly stark statement. In other words, if you don't, as a transport manager, if you're not complying with the guide, then you are in at least tarnished good repute territory. So I think the writing is on the wall. It's a very clear what is being laid down. So that the guide is not some, sort of take it or leave it helpful document. It is something, the provisions of which actually need to be followed. You can theoretically find an alternative, I suppose, but it's going to have to comply with everything in the guide, be at least as good. So next slide, please. I thought we'd just, in this next couple of slides, just go back and remind ourselves about brake testing, why it's done, and the legal provisions, and put in a couple of helpful pointers that you may not know about and which could help your drivers. So in the guide, perhaps this isn't sort of news, it shouldn't be. The basic legal requirement is that every part of every braking system has to work. That's the bottom line. If it isn't, it's an offence under the Road Traffic Act 1988 and the Construction and Use Regulations. If it's an offence, it can be dealt with by way of fixed penalty. If it's an offence, the defendant can be fined and receive 3 penalty points on the licence, which I'll come to, or be disqualified. There is a provision in Regulation 18 which you as operators and transport managers might know, might not know, and may be quite helpful to deal with DVSA and driver issues. Because following on from the first part of Regulation 18, it says in terms that if a vehicle's got ABS and it's got a fault, then that is to be ignored for enforcement purposes, because the condition is fulfilled while the vehicle is completing a journey at the beginning of which the ABS was operating correctly, or is being driven to a place where the ABS is to undergo repairs. So it's a sort of insurance policy, if you like, for drivers who properly carry out procedures. The brakes are working, and the ABS was working at the start of the journey. So if you have an encounter with the police or DVSA, this might be a trump card that you want to pull out to argue that the ABS was working, whatever. So I just thought I'd put that in here just as a reminder. It may be I know that some of you may know about it, but it may be less familiar, but it's worth knowing that one. And as I've a reminder there at the bottom, so far as the DVS guide is concerned, every single inspection of a vehicle has to assess brake performance, and that means there's a formal performance assessment, not road test okay, or brakes look all good, or whatever it is that we sometimes see on sheets. So next slide, please. So I thought I'd just mention this again as a help to you as an operator and for drivers. This is a bit of the Road Traffic Offenders Act 1988, which is not well known, but could be again pulled out for you as operators or transport managers when dealing with DVSA. If you have got a problem with brakes or steering or tyres, I mean, I know that we're looking at brakes in this presentation primarily, but it applies to those as well. And the driver, or in fact the operator, if it's a person or a sole trader or partner who's got their own driving license, not a limited company that doesn't, then they cannot, the court is forbidden from disqualifying or entering penalty points, imposing points on the license, which will be normally with the driver's license, if that he or she proves he didn't know, had no reasonable cause to suspect that the facts of the case were such that the offence would be committed. So in other words, if you've got no reasonable cause to believe there's an offence, then you can't have your licence endorsed. And by extension of that, my argument is DVSA and the police can't issue a fixed penalty with 3 penalty points attached to it, because that flies in the face of that. So it is worth knowing about that provision. And also, interestingly, it applies to dangerous condition offences. I dealt with a case a few years ago where a tyre flew off the back of a lorry. The driver didn't know that the previous night the wheel had been off and reattached, and so needed to be retorqued. And we went to Ely Magistrates Court, argued this, and we had no fine, no points, and no costs. So it is, I know that we don't have prosecutions much these days, but it is something which I hope you might find interesting and a tip. So let's quickly move on then to what's actually in the guide itself. If we go to the next slide, please. What it does is the guide sort of talks about where we are at the moment and then pushes on to say what we need to do from April 2025. And in brief says the 3 modes of acceptable brake testing is the EPB MS, which my understanding is only really on trailers, a roller brake test, or a decelerometer, as long as you comply with all the conditions attached to the EPBMS or a decelerometer. So that's the basic situation. If we move on, please. There is then the question of meaningful tests. We often hear traffic commissioners at hearings saying, why are you paying for unladen tests? They are meaningless. It's money down the drain. The guide says that sort of vague language in one sense, where possible, tests should be laden. Traffic commissioners may often say, well, I want it laden on every single one. But as I say, that's a separate issue. There will be, and we'll come to this, some vehicles that can't be laden. For example, I know the passenger sector is represented on this call, and one of the specific exemptions from laden testing is for PSVs and other types of vehicles that simply can't be laden, or it's very difficult. But they're saying that the bottom line otherwise has got to be a minimum of 4 laden tests. So if you've got long inspection dates, well, effectively that's going to be every one during the course of the year. But you're going to have to, if you don't do a laden one, you're going to have to do something that still complies to assess performance on the other ones. The guide also says that if you don't do a laden test, there has to be a risk assessment. Now, it cranks up the wording of this, I think, a bit for post-April, but there has to be a risk assessment if you don't do a laden test. And it's got to be done by a competent person, signed off by the operator, and that you have to have evidence of having gone through that process to determine if you can do some of them unladen. And a competent person is somebody who's got the skills and knowledge and training and what have you to do that. And the guide provides a risk assessment that you're going to have if you're going down this path with risk assessments and not doing laden all the time. You're going to have to manoeuvre around. So let's move on then, shall we, to where we are post-April 2025, and then after that, Dave will have some input as to the actual practical problems. So from April 2025, the situation remains. You have to have a performance assessment every inspection. That is non-negotiable. So there cannot be road test okay, or I've inspected the brakes, visual inspection and things like that. That isn't a sufficient platform. It states that there's an expectation that it'll be one of the three methods. I mean, for expectation, read, it's mandatory. I think it's just the wording of it. So you either have a roller test or the EBPMS or a decelerometer, and if the latter two, you've got to comply with all the additional requirements. They confirm that you've got to have a minimum of 4 laden tests evenly across the year. It can include the annual test. If some you're intending of doing as unladen. I think there's a school of thought, why don't we just do laden for every single one? What is the point in doing, if you're doing 6 a year laden, why not do 8 a year laden? You know, is it more trouble than it's worth to have a mixed way of doing it? The guide then confirms that you have to do risk assessments for situations where you're not doing a laden test. The wording is a bit confusing in the guide because it's not entirely clear whether if you're doing EBPMS you're excused the laden testing, because 2 sentences say 2 slightly conflicting things. But I suspect that not a large number of people may be doing this anyway. The next thing is that there has been a change in when you can present your vehicle or trailer for brake tests, and they have upped that to 14 days. Currently it's 7 days prior to the inspection date. So if you, for whatever reason, you've got a greater amount of latitude for when you send the vehicle in, if it can't be done on the day of the inspection. And then finally, before Dave has some words, the situation is what happens if you've got vehicles and trailers that can't be laden. They are listed in the guide. Well, they've got to do 4 roller brake tests, effectively unladen, but you still have to do the risk assessment to address that and comply with the guide. Now I've mentioned PSV vehicles. There are other vehicles like car transporters. I know on this call there'll be a business that does car transportation work, livestock carriers, noxious load carriers, furniture removal, and there are vehicles operating at 50% or more of the permitted axle rates when unladen, or when, and so there is a list of them in the guide if you want to just check that. So that is the situation from April 2025, and we'll come on a bit later to what documentation you're going to need. But that is the main crux of the change in the guide, with effect from April 2025. And with that, we'll move on to the next slide. And thank you to Dave Cooper for being part of this. And I'll hand over to him to tell us a bit about the practical challenges that face operators and where things are not fully understood, perhaps.
Okay, good afternoon, everyone. Some of the things we found during our training and rolling out our training program to technicians is lack of understanding on working out the values, how imbalances occur, what the meaning of pass is on locks only, and how semi-trailers pass but on an unladen condition. And then, of course, the understanding of secondary braking systems. So I'm just going to recap on those items today. Hopefully gives you a little bit better understanding of reading your report. So first of all, if we start with working out the values. So a lot of people say to us that we get the brake test report, and if it says pass at the bottom, then I'm happy with that. But we need to understand how we get that value. So at the bottom of your brake test report, to the left-hand side, you will see the pass value. So if we talk about a service brake, for example, on a vehicle, it would be required to be 50%. Then you would get your test value, and then it would state then as, which is actually what was achieved during the test. Then it would state, of course, as to whether that vehicle has passed or failed. I'll come on to the bit where it's got locks in brackets in a little while. But how do we get that value is the question. Well, when we look at the service brake, that is actually taken from the total axle weight. If you look down the right-hand side of any brake test report, you will see maximum effort achieved in kilogram force, which is how it's measured. That is all totaled up, and then it is divided by the weight as per it sits on its maximum on the road. So that is its total axle weight. So, for example, it could be 45 tons, something like that. That is then that weight. Sorry, that brake effort is divided by the weight, then times by 100, which gives you the percentage. For the part brake, it's divided by the gross vehicle weight, which should meet 16%. For those of you with tractor units, you'll notice that the part brake is actually 12%, and that's measured on the gross train weight of the vehicle, because it's assumed that at any given time with weight on it, it would be coupled to a semi-trailer with the imposed weight, and therefore percentage of the brake effort taken from the trailer. Okay, so gross vehicle weight is done on rigid vehicles and a standalone trailer, and that should equal 16% on a part brake. So that's something perhaps you're not aware of there. That's measured on the gross vehicle weight, brake effort divided by gross vehicle weight times by 100, and that gives you your result at the bottom of that. So from that point, working out the values, we can also then look up and down the sheet on the right-hand side to see where the values are weak. Because, for example, we get a 50% requirement for the pass value test, and we only get 38%, let's say, at the actual test. So there's a weakness somewhere in brake effort. We can then establish that by looking down the right-hand side and working out which axle, which hub isn't performing correctly. Okay. We also then get, moving on to imbalances, difference between the brake effort from the left-hand side and the right-hand side of any axle. 9 times out of 10, this is not caused by a mechanical problem. This is often by the technician or the person presenting the vehicle for test and the way in which they apply the brakes. It's very clear in the HGV manual that brakes should be applied gently and released gently. Even with different shoes, this can make a difference, and we've proven this through testing and training. Soft shoes compared to someone who works in steel toe cap boots all day will make a difference. It does sound bizarre and it sounds minuscule, but it is the difference. Other things that cause this are tyre pressures on vehicles as well. A tyre pressure difference of 10, maybe 20 psi can make a massive difference on the rollers. The vehicle will sit heavier or lighter accordingly. So these are some of the reasons for imbalances. That also, coupled with fuel in the tank on one side and the other, adds to fuel to the fire. If you've got an imbalance of more than 20%, certainly on a steered axle, then you should be questioning as to whether or not that needs to be retested. Traffic commissioners will say, I don't like it above 25%. Then the DVSA, and this is where it gets confusing, in the guides say, or sorry, in the HGV manual say, that we'll go up to 30% if the wheels don't lock. However, if one wheel locks on the axle and the effort is less than that of the wheel that didn't lock, then it would be considered a pass. So that's how you get that one. Moving on to that, meaning of a pass on locks. So we've already spoken about the test value, which doesn't meet the actual pass value. Therefore, the exception to the rule is that if the hubs on each axle lock and it doesn't meet the pass value, then it will be considered pass because all wheels have locked out and therefore the brakes can't do any more. Does that make for a good brake effort? No, it doesn't. The one thing we have to remember is, and Tim clearly said, that traffic commissioners and anyone else in this will say a brake test unladen isn't worth the paper it's written on. We have to consider, in the worst case scenario, and we've already seen this 8 years ago, that if a vehicle is involved in a fatal accident and at that time, let's say for example, it weighed 10 tonne unladen, your brake test of an unladen brake test report is showing 10 tonne, that's fine. The court are going to look at that and go, okay, it was tested to that. However, the next day when you're fully loaded at 44 tonne and your brake test report shows 10 tonne, then that test isn't worth the paper it's written on because it's not showing the vehicle trailer was tested at that given weight. So another good reason why we have laden brake tests. Pass on locks can often be considered as putting air brakes on your car. You've got a very light vehicle that has a braking system suitable for stopping a vehicle with double, even treble the weight. So passing on locks is not always an ideal situation. You will get a pass on locks even on a laden test, but the key there is to look at the amount of effort that has been applied through the service brake and secondary and part brake. If that's quite high, somewhere around about 2,000 kilogram force, then we know that there's been effort applied before the wheels lock up. You won't get one without the other. If you haven't got weight, you won't get brake effort or brake force effort. Okay, so one won't go without the other. We need the weight to allow for that brake effort to be applied. If you take the scenario of spinning the front wheel on a push bike and just dabbing the brake lever, the wheel will just snap on. That's exactly what you're doing on a vehicle that isn't weighing much at all and has a braking system to manage a lot heavier weight. Okay. Semi-trailers that pass unladen. There is a ruling from DVSA, and it is, again, it's in the HGV inspection manual, that this is only on triaxle trailers as well. And for any of you that run skelly trailers, you will even struggle with this. But if all 6 wheels lock and the total effort achieved is 3,000 kilogram force or more, then it will be considered a pass. If 5 wheels lock out of 6, you'll need to obtain 3,600 kilogram force. And if 4 out of 6 lock, you'll need 4,200 kilogram force. So that's the total added up down the right-hand side of your brake test report. Okay. Any less than that, then it would go back to normal conditions of 45% required. So that's how semi-trailers pass unladen. It's realised through industry that to get 65% of the laden weight on the 3 axles on the back of a triaxle trailer is dangerous on the road because you haven't got 20% imposed on the pin, and of course could potentially cause them to be overloaded. The key and successful way of doing this, if anyone's thinking, how do I go forward with that, is to look at your service provider or yourself to either have pull down or push up roller brake testers, which are becoming more and more popular in the UK. And they certainly resolve the problem for triaxle trailers. Okay. Secondary braking systems. Some may remember these, some won't, but years ago, when we started driving back in the 70s, 80s, not me, I'm younger than that, but there you go. We had two handbrakes on a tractor unit. One was a secondary brake. You also had a blue airline as well. These have long since gone, but that's what the secondary braking system was. It was a fail-safe. It's still recorded. However, quite often it's amalgamated with the service brake. And for that reason, when new brake testers come out and new requirements are put into force with brake testing manufacturers, we will no longer see the secondary brake as a pass or a fail. It will be in the reports, but it won't be a pass or a fail. It's assumed that the secondary braking system works with another progressively applied system, i.e. being the service brake. The secondary brake is more often than not integrated with the service brake, and it is split between the front axle as a standalone and the rear axles. So for a 6x2 tractor unit, it would be the rear two axles together are the split of the secondary brake and the front axle. That effort of 25% then has to be applied. Okay, so that's that. Some of you may have seen a pass alternative on your test. Where that is the secondary brake, and this quite often relates to a tag or a lift axle on a tractor unit. Hasn't been set down in the rollers properly, which is a good tip, is to just drop suspension or lift it up to its maximum and then reset it to push the axle into the rollers. The brake effort doesn't get met, and therefore they use a pass alternative by totaling up the total axle weight through the service brake and the effort that's been applied. Okay. Hope that's been helpful for you. Tim, back to you.
Yeah, thanks very much, Dave. And it occurs to me that obviously you've been able to provide some of the more technical information, and it may be that there is interest in the future for us perhaps doing a dedicated session to helping people understand this area. Before you go, not that you're going anyway, I'm not anticipating. I know that you're here to the end. We ought to pick up. Claire has very kindly dropped into the to the question box this issue about scally trailers. 2 questions, and we'll just come back to what you were talking about, because she says there, our maintenance provider asked me to ask a question. Skeleton trailers are only required to have an empty test on MOT. This means that you must do a loaded and empty brake test. Is this correct? And I said I'd pick that up. So my understanding is that in terms of performance testing, let's forget the laden bit, what the provisions are for an MOT is what the provisions are. But so far as the Guide to Maintaining Roadworthiness and Traffic Commissioner Expectations, there has to be a performance assessment of some kind that is going to be meaningful. And so one does ask the question, how does an operator satisfy themselves on this particular point outside the annual test?
So that's a good question. We actually have a customer at the moment who's struggling because if you put a 20-foot ISO tank on a triaxle trailer, which they've tried to use as a laden brake test, then of course the weight's not in the right place. We get the weight overall, but we don't get it in the right place on the axles. DVSA have also been working with us on this particular customer. And at the moment, to be honest, there's not 100% solution on this because, of course, as Claire probably said and knows, when a tracks or skelly trailers put into the rollers, there's just not enough weight there to provide even 500 kilogram force on each wheel.
Yes.
And therefore it will fail because it isn't given enough brake effort and it's not going to lock out. My advice is, if you can get a load or weight to put on it, then take it laden. The benefit of this, of course, as well, is that if the vehicle is laden, it opens up load sensing valve underneath as well to apply full brake actuation, which doesn't happen when it's empty. So where possible on that, try and get the vehicle laden. This is, certainly for my customer, we're looking at how we can manage this by putting weight on the back of it. Or alternatively, other than for test, if you can search for a service provider that has pull down or push up rolling brake testing, then that would it would overcome the problem, because of course they can apply the weight by simulation.
Yeah. Okay.
Okay.
Well, thanks very much, David. I mean, it may be that I can link you in with Claire and others to pursue this bit further, because it's to do with the the sort of technical issues and problems that arise. Well, we can pick up any further questions that may arise in a short time, but thanks very much, Dave. If we can just sort of pick up the last part of this presentation and what comes out of the changes in the guide. Well, just to finish off the brake testing, record keeping, you will hang on. Sorry, that's right. Yeah, sorry, the slide was shifting. We're still on this one. So basically, as you have to continue to retain all your records for 15 months, which is the mandatory minimum period, you are going to have and retain chapter and verse documented of every single aspect, to summarize every single aspect of the different performance methods that you may use. All brake tests to be signed and dated attached. I put signed in bold because this has been cropping up. The brake test being attached to PMI sheets, but DVSA taking issue with the fact that they're not actually signed. We've had down marking on desk-based assessments and DVSA visits on that one. So just be careful on that particular one. So in essence, you're going to have to make sure that you've got the full suite of information and your risk assessments. Just a final point on risk assessments. The guide actually says that you don't have to do a risk assessment for every single occasion when you don't do a brake test. You can have one where, if there's no change in the circumstances for a particular vehicle or trailer, they can roll over. So you can have it up as risk assessment for up to 12 months. But the inspection sheet is going to have to make reference to there being a risk assessment. I think that's the key to it. And finally, the last, if we can just move on to the next slide, I wanted to say two slides. The final two things that have been reinforced in the guide is, first of all, the management of maintenance contractors who are unregulated, and as I said, it is a big issue. What traffic commissioners like to see, from my experience in hearings, is an operator meeting up with the maintenance contractors to talk about things, looking for trends, auditing the inspection sheets when they come back to the maintenance contractor to actually use that as a form of auditing not just the drivers, but actually the maintenance contractor themselves. And so there needs to be huge oversight in what is in effect an unregulated sector. The final slide, in fact, is about safety recalls. which I did want to mention, because there seems to be some misunderstanding on safety recalls, and operators are being marked down on DVSA visits and on DBA, desk-based assessments. This section has been updated with a different link. The requirement is not that you simply respond to safety recalls. You know, the dealership will get in touch with us or whatever it may be, but you actually have to have a system in place where you decide how frequently you're going to look up vehicles to see whether or not there have been any recalls. Now, this isn't just DVSA, this is actually in the Senior Traffic Commissioner guidance, because the guidance actually says that operators need to have a risk-based approach to this and decide, you know, how frequently are we going to do this? We don't need to do it every week, but, you know, every 3 months might be too long or whatever. And I can think of a couple of instances where our operators on DVSA visits have been marked down from satisfactory to mostly satisfactory purely on that point. So if you don't already have that regime in place, could I suggest that you start to do that and have that so that you're fully equipped to deal with any issues and any inspections from DVSA. So if we just move on to the next slide, that is, we did say sort of 40 minutes to an hour, and I think we've kept to our timetable. If you've got any questions at all, then just do put them into the question and answer facility there, or the chat facility, and we'll try to deal with those. If there aren't, we'll give you a short while to deal with that. And if there isn't anything, we'll say thank you very much indeed for your attendance this morning, and we look forward to seeing you again on future presentations, which we haven't done for a little while, in fact. I think you can get, we can send on a copy of this recording to you, which will be made available if that's helpful for you to disseminate wider to your transport teams. Yes, we can share. I'm happy to share the slides. So question in from Kev Burton. Yes, that's absolutely fine. Right, so there's a question from Laura. Hello, maybe self-explanatory, but will past tests be scrutinised for not being laden by the DVSA? Is April the start point, as it were? Well, I think the answer to that is, like all things, you're expected to comply with the regime or the law as it is at the time. So if there is currently a non-compliant regime, even by today's standards, then it can still be attacked by DVSA. They can still ask the question, well, you know, were you carrying out a brake performance assessment at every single PMI or inspection? So the answer is, with effect from today, well, effect from the 5th of November, you are expected to be doing one of those 3 brake performance assessments in the way described. And in fact, doing it refers to risk assessments even now, even though I don't think, perhaps I'm out of the loop, I don't think people have ever been doing risk assessments. I don't know what Dave's experience is.
No, I've never come across them. I've done numerous workshop audits and audits for Traffic Commission and various others, and no, not seen one yet. And for those of you still there, I do have a concern with risk assessments, and I think, Tim, we touched on this the other day, that whenever there's a health and safety incident, the outcome quite often, as I've read in cases before, is the risk assessment didn't go far enough. So food for thought if you're thinking of going down the route of risk assessments rather than having a brake test.
Yes, the Annex 7, I think it is they do give a template of the risk assessment that's got to be signed off not by the competent person, and it has to be signed off by the operator. I suppose if in your own risk assessment you put everything that is in that template, well, how are you going to be criticised if by DVSA or Traffic Commission we're only doing what you have expressly asked us to do in the guide? What's the problem, I think? Yes, I mean, the other point I was going to make, Dave, which you might need to comment about, is in relation to EBPMS. Now, I know that some people have spoken to us about using this system in anticipation of April, so they're getting their trailers all kitted out with this so that they've got in-service testing and also for the inspections. I'm not aware of it. The guide actually refers to vehicles and trailers. Perhaps it's me. I'm not aware of this being used on vehicles.
It is only trailers that I'm aware of. I'm just gonna open up my ER audit because we've got a new process coming through for that, and they do mention that in there. So if we look at that as being the benchmark of the industry, then perhaps I can give sort of some clear direction on where that's going to go.
Because you do earned recognition accreditation, don't you?
Yeah. So what they're saying now is that if electronic brake performance monitoring systems are fitted, how they monitored. So that's one thing. Obviously, that needs to be done by a competent person as well. So that's the first consideration. The EBPMS trailer connection, it is a legal requirement for the trailer to have the proper connection. Then it says, please note, minimum of 3 meaningful laden assessments plus MOT every safety inspection. The braking performance must be assessed. It doesn't really tie to anything. So they're not, again, they've left themselves a little bit exposed in the question in there. So what they're saying is we've got to have a policy, give details of the frequency, test type and condition, whether you're laden or unladen, risk assessments present in the vehicle files for any exemptions. If EBPMS are fitted, how they're monitored, and then the EBPMS is a legal requirement for trailers to be fitted with the correct EBS connection to make it work. So they don't actually say, unless there's any further, as to what they're expecting. And that's as far as they go. So they're not giving away a lot there, to be honest. My view is that if you've got EBPMS, then you don't need to do the roller road brake test, but there is no clarification of that. Must emphasize.
That was the point that I made earlier, wasn't it? There are two paragraphs which are slightly conflicting, it seems to me.
Operators are spending a lot of money on the system. Certainly for park brake, unless there's been systems updated, and you do need to look round before you purchase these. The park brake was going back to a drag test at one point. So you literally apply the brake, and if it doesn't move when you try and tow the trailer up the yard, then that's good enough. Which, a little bit draconian. So yeah, other than that, I think it does have some benefits, and it's one of those things at the moment. It's progressing well. There's a couple of key manufacturers out there that are doing the system, and I think operators are seeing some benefit from it, and it's acceptable by DVSA. But just clarify as to whether you still need to do any rolling roads or not, because of course MOT will still go through the rolling road brake test. So
okay, I think I don't think there's anything else. There's nothing in the chat. There's nothing in the questions. We've got brilliant timing actually. So we're just coming up to the hour mark. So I'll say thank you very much indeed for everybody. Oh, hang on, we've got a further question. I'm not sure if it's being typed at the moment. Oh, sorry, I've got it. I've missed it. Sorry, it's in the question and answers. Oh, it's about recall. So the question was, can recall checks be spaced further apart as vehicles get older, as they are unlikely to get as many recalls? From Peter. My answer to this might sound as if it's going to be a fudge. I think what you need to do is you need to just see what it says in the guide, and you go back and say you adhere to what the traffic commissioner has said, and you say, well, you just take a risk-based assessment of this. You say, this is our fleet, these are older, these are younger, whatever it is, and we think a proportionate way of dealing with this is to do the same for everybody or have different ones for different vehicles. I think that's the answer. I don't think you need to be doing a check every week. I don't think you need to be, have very, very long gaps. But I do take the point that if you've got vehicles that are really old and they may never have any recalls at all for, I don't know, then what do you do there? It's unlikely to, you may be unlikely to receive anything. So I think that we'll call it a day then. Thanks very much. Can I also thank Emma and Holly in our team who've sort of dealt with all the administration and the running of this webinar as well. So thanks very much and goodbye to everybody, and we'll see you again soon.